Ever wonder what a truck company's own rulebook can do to them in court? That little binder full of safety rules is basically a diary of promises, and when a driver breaks one, the company basically wrote the confession themselves. Think about it like this. Your school has a rule that says no running in the hallway. If a kid runs and knocks someone over, the school handbook becomes evidence that the rule existed and somebody ignored it. Commercial trucking companies have these thick internal manuals, way stricter than federal law sometimes, covering things like maximum hours behind the wheel, mandatory rest breaks, and phone use while driving. Lawyers love these manuals because they set a private standard, and breaking your own rule looks even worse than breaking a general one. The first piece of evidence attorneys chase down is the electronic logging device, or the ELD. This little box tracks exactly when the truck moved, stopped, and for how long. So if a driver was supposed to rest for 10 hours and only took 6, the box does not lie. Next up is the driver qualification file, which sounds boring but is basically a background check on steroids. It shows training records, license status, and any prior violations, so if someone was driving without proper certification, that file becomes a spotlight. Dispatch records are another goldmine, showing texts, calls, and messages between the driver and the company. If a dispatcher pushed a tired driver to keep going past the legal limit, that message thread can turn into the star witness. Here's where people get confused. They think only Federal Department of Transportation rules matter. Nope. Private company policies can actually set a higher bar, and violating that higher bar still counts as negligence in court. Maintenance logs matter too, because trucks need regular inspections like brakes and tires. If the log shows a known brake issue was ignored for weeks, that paperwork practically screams negligence. Cameras inside the cab, called driver-facing cameras, have become a huge deal recently. They catch things like phone use, drowsiness, or distraction, and footage does not really leave room for excuses. Company training materials are pulled too, showing exactly what the driver was taught to do versus what actually happened on the road. If training said always check mirrors before lane changes and the driver skipped that step, the manual and the mistake sit side by side. Let us bust a myth real quick. People assume lawyers only care about the crash moment itself. Truth is, they build a timeline going back weeks, sometimes months, to show a pattern of ignoring safety, not just one bad 5 seconds. Speed data from the truck's own computer system is also huge, since most trucks track speed constantly. If company policy capped speed at 65 and the truck was cruising at 78, that number becomes very hard to argue with. History shows us this evidence gathering exploded after electronic logging became mandatory back in 2017. Before that, paper logs could be faked pretty easily, so this shift genuinely changed how these cases get built. The real lesson here is that trucking companies write their own rulebooks, and those rulebooks can become their biggest liability. Preparation and documentation are not just legal buzzwords, they are literally the difference between a driver walking free of blame and a company facing serious consequences. So if any of this made you go, I did not know that. Want to learn more about how our company helps with cases like these? Check out the links in the description.